And Lee Strang is my guest, 7:44, 69 from the top of the hour. He is he's over, actually, I've heard, correct me if I'm wrong, Lee, but I understand you're going to be responsible in September for all the trick plays that the Rockets are going to have this year. Is that any truth to that at all?
I try and stay out of that.
Do you really?
I got enough on my plate.
I got that. Well, let me, because our time is limited,
Sure.
Let me jump right in. I don't get the sense that there is any constitutional relevance in the hearings right now in Washington with regards to Sotomayor. They got a 60-40 split, Democrats to Republicans. This whole thing is pretty much ceremonial, and I'm not hearing anything coming out of the Democratic side showing any concern whatsoever, or any recognition, for that matter, of the constitutional principles that a Supreme Court justice should be touting.
Sure. I think that the confirmation process, Brian, when you see these hearings, they're really a microcosm, or they're a reflection of the broader society. So you can think of the Constitution being relevant in two areas. One is politics, maybe another is law. And in the confirmation process, you see the politics, don't you? You see the Constitution is used by the different political parties, or is referenced by the different political parties to both encourage their base, but also to put forward a message of what they think the Constitution properly interpreted is. So the Republicans, for example, they want a limited national government. They want an originalist interpretation, what the framers and ratifiers understood the text to mean. And the Democrats don't want those positions. And I think those have their political correspondence as well. So the Democratic Party generally is the party of larger government. They're the party that is therefore going to want an interpretation of the Constitution that's not limited to what the framers and ratifiers would have wanted. And the Republicans are the opposite of that. They want the limited government, and therefore they have an interpretive methodology that leads you to a limited spending power, or a limited Commerce Clause
But
power.
which one is best for the? Obviously, I asked this question from an obvious prejudice. I don't make any bones about it. I'm an originalist. I'm a big fan of Scalia and Thomas in their interpretations and their renderings. I wasn't real thrilled with the Heller decision, at least in its depth, on Second Amendment, and so on. But that's neither here nor there. There appears to be a subjective interpretation or application or desire on the liberal side, and an objective on the Republican/conservative, generally speaking. Although both sides find the Constitution convenient, as opposed to a beacon or a GPS as to how they do their legal stuff. So wouldn't it be more important? And I don't get the sense that it's coming out. Wouldn't it be more important when we're looking at Supreme Court justices that the objective perspective be explored? And I also like to hear your comments on the concept of a living Constitution. Exactly. Have you seen one? I've tried to capture one. I carry a net in the car, rope, that kind of thing.
I think they captured it back in 1787. It's in the National Archives.
Is that right? Okay.
So you raise a good point, which is in the confirmation hearings you have different interpretive methodologies about what the Constitution, or how we know what the Constitution means. And I think if you go focusing on the Republican side for a second, Jeff Sessions, the senator from Texas, if you go to his website, he has posted his questions that he's going to ask for Sonia Sotomayor, and they are really great questions. When you say that, like Sonia Sotomayor said yesterday, when you say that you're committed to the rule of law and judges only enforce the rule of law, what do you mean by the law? Does that include just the Constitution's original meaning, or is it that plus empathy, or is it just empathy? Because I think what the dispute really is, and Judge Sotomayor tried to ward off this by professing her adherence to the law, is what is the law? And the one side says that you look to what the framers and ratifiers said in 1787, 1789. So when you ask, what does the Commerce Clause mean? How much power does Congress have to regulate under the Commerce Clause? Do you ask, well, what do we think today is best for Congress, if you're 9 Supreme Court justices? Or do you say, what did that mean in 1787? And if we don't like what that meant, we have recourse, don't we? We can try and amend the Constitution. We can try and have states pass statutes that can essentially get to the same effect. So we have a lot of ways to work with the Constitution's original meaning, even if we're not happy, but at least we know that there's something there. There's something, as you were saying, that's objective. And on the other side of the coin is essentially a family of theories, what most people call non-originalist theories, where anything from the judge's own perspective about what's just in this case, or where empathy should lie. Think of the Ricci decision, where Frank Ricci, one of the white firefighters in New Haven, apparently empathy didn't lie with Frank Ricci. and instead, because I'm not sure what the reason would be, but he wasn't empathetic enough for Judge Sotomayor, or is it something else? Is it what most people today think is justice or cruel and unusual punishment? And if that's the case, what's the point of a constitution, right? If a constitution is supposed to restrain both the elected officials, including, government officials, including judges, and the people, then what's the point of tying that to some kind of changing meaning? And I think it leads to a lot of problems, like the confirmation process, where because judges are going to wield such extraordinary power in the purported interpretations of the Constitution over life and death, think of Roe versus Wade, over religion and public life, think of Everson versus Board of Education, judges wield such extraordinary power in our society in a way that they should never have done, that the confirmation process becomes the place where the future of our country in large measure is decided.
Well, yeah, on that note, with the subjective objective aspects, as I mentioned off the air, Walter Williams, an old and dear friend, had a great example in the discussion of the living Constitution. He said, to fully understand the implications of the concept of the living Constitution, how about this? Come on over to my house tonight. We'll play poker according to my living rules, and bring lots of money.
Sure.
Which I thought is a great way of putting it into perspective. That and Tom Sowell had another great comment that I've used often. I paraphrase it. But the essence is, it's not necessarily what's best. It's who gets to decide what's best.
Sure.
And without the restraints and the constricts and the principles of an originalist constitution application, then you wind up with, like you say, this magic slate where it's, well, what this particular band of looters or whatever happen to decide is best for that moment.
And I think one of there are a number of obstacles that originalists face, both on and off the court. So off the court, I think it's fair to say that many Americans like large government programs. They like having the security of, for example, Social Security. Farmers like to have huge agriculture programs that funnel taxes from city dwellers to farmers. And in the legal field, it's fair to say that originalism is definitely not the dominant theory of interpretation, but it is gaining some strength. So, for example, the Heller decision, which you referenced earlier, District of Columbia versus Heller, it said for the first time that the Second Amendment protects an individual right, and that I think 20 years ago, that decision would not have happened because there were not Supreme Court justices who were originalists, and because originalism was so out of favor then, it's still out of favor now, but it was so out of favor then that it wasn't even plausible to raise it as an argument, like it is now. So now in the Supreme Court, it's legitimate. In fact, many of the first arguments that are made before the Supreme Court or by the justices themselves are originalist arguments. And so there's really been some gains there. And I think Americans, especially when they see an economic crisis, they see a government that they perceive as spending too much money, they see a presidential administration that is expanding its control over auto companies, banks, et cetera, they're becoming really concerned. And what do you do when you're concerned about yourself or your country? You try to go back to your roots. And what is America's roots? Where is America's constituting document? It's the Constitution. So I think there is now an opportunity for people to present the Constitution in the best interpretive methodology.